Today we have to talk about the Consumer Protection Act 1986. Yesterday we talked about the consumer protection movement and the various other legislations apart from the one which we are going to discuss today. We talked about the other legislations which are there and which basically serve the interest of the customers, of the consumers. And now we are going to discuss the Consumer Protection Act 1986, which is the main topic in this particular unit. So what does the Consumer Protection Act do? It protects against unfair trade practices and defective goods and services. So basically it protects the customers against unfair trade practices by the sellers, against the chances of being sold defective goods or services. And in the Consumer Protection Act, actually some rights of the consumers have been defined. So basically Consumer Protection Act 1986 guarantees some rights to the customers, to the consumers. What are those rights? Let's have a look at them. Protection against marketing of goods which can be hazardous to life and property. So the goods which might cause damage to the property of the user, which might cause risk to the life of the user, to the life of the consumer. These kinds of goods, if they are being sold to the consumers, they have now got this right that they can seek protection against being sold these kind of goods. Now, to be informed about quantity, quality, potency. Potency means the power, the strength, the purity and price of goods. And this is why you see that in various packagings you have been told, you are given this information about the quantity which is there in that particular package, what is the price, what is the quality. If you talk about any food item, ready to eat food items, for example Nestle, Maggi noodles or other noodles, or maybe there are so many ready to eat food items nowadays which are getting sold, you would find that nutritional content is also specified on the packaging. The date of manufacturing, date of packaging is also there on the packaging, plus the date of expiry is also there on the packaging. So all this information has to be there on the packaging, and the customer should be able to access this information. In fact, even the font size of this information has been specified. What should be the font size of this information, so that the customer can easily make out what has been written on the package and what is the information which has been furnished on the package. So to be informed about quantity, quality, potency, this is another right that the consumer has been now guaranteed. To be assured of access to variety of goods at competitive prices, so that he can make a choice and he can go for the best quality goods. He does not have to go for whatever is the seller is trying to sell to him. He may go for comparisons, he may compare the various goods which are available in the market, and then accordingly go for the goods which best suit his requirement. So this is again another right which has been guaranteed to the consumers. Then to be heard, this is a right which has been guaranteed to the consumers. Now what do we mean by to be heard? To be heard means, in case the consumer has some grievance, there should be some platform where he can voice his grievance, where he can voice his complaint. And that is why, if you look at this particular ad which has been shown here, I have given you this particular clip here, this particular ad here, and have a look at what this particular ad says. I'm a smart consumer, and have a look at this phone number. Now what is this phone number meant for? In case you have got any grievance, you are not satisfied with the quality of the product or the service which has been sold to you, you can call upon this particular number and you can file your complaint. Is this okay? So this is a right which has been given to the consumers. They can be heard, which means they can actually voice their complaint, they can raise their voices against being sold defective goods. So this is one more right which has been provided to the consumer. The customer has the right to also criticize the quality of the product. And that is why in social media also you see many a times, if you're not satisfied with a particular product, there are so many customers who are not satisfied, they can voice their concerns on the social media. So this is a right which has been given to the consumers. Then to seek redress, not only can you voice your complaint, but also you can seek redressal of your complaint. What do we mean by redressal? That your complaint is not only heard, but appropriate action is also taken. So in case your complaint is found to be verified, it's found to be true, then you should be given some compensation, or maybe you should be allowed some the seller might be directed to replace the product that has been sold to you already. So replacements might be ordered, or maybe some compensation might be ordered. So these kind of redress, they are available for the consumers under the Consumer Protection Act. Then not only this, now have a look at this particular photograph. Here you find that even not only we have a phone number here, but we also have this particular Jago Grahak Jago theme. Now what is basically Jago Grahak Jago? You might have come across so many print advertisements on the same theme. You might have you might have seen some of the video advertisements, the visual advertisements. You might have come across such advertisements on television also. Jago Grahak Jago. Now what is basically Jago Grahak Jago? Don't you think this is basically an endeavor to educate the customer as to how many rights does he have, what all rights does he have, how to lodge complaint in case he has been sold out defective goods or service, or he is not satisfied with the quality of the goods or services. So basically this has an element of consumer education. This is again a right which has been guaranteed to the consumer against the Consumer Protection Act. So that is why we have these kind of Jago Grahak Jago theme ads which run in various television channels. So basically this is an effort to educate you as a customer. To be assured of consumer interest receiving due consideration at appropriate forums. So another right which has been guaranteed is that the consumer interest would be given due consideration at appropriate forums, which means whenever, let us say, some particular law is being finalized, is being formulated, let's say whenever some regulations are being thought of, some regulations for the markets are being thought of, whenever there are these kind of new regulations coming up, in all these places, on all these platforms, the consumer interest would also be prioritized. So these regulations would not be finalized, these laws would not be formulated without regard to the interest of the consumers. So whenever these kind of developments are taking place, the consumer interest are certainly going to be considered, and this is another right which has been guaranteed to the consumer. So whenever, let's say for example, if the government enters into an agreement with the retail traders, there is an association, there is a trade body of retail traders, so association of retail traders. So in case the government finalizes an agreement, inks an agreement with these traders, the government will have to consider the consumer interest also while finalizing these kind of agreements which may have a bearing on the consumers. So in all such platforms, wherever such developments are taking place, the consumer interest will have to be considered, and then only an agreement can be inked, or a regulation can be implemented, or a law can be formulated. So this is again another right which has been guaranteed to the consumers under the Consumer Protection Act 1986. Now let us have a look at the Consumer Dispute Redressal Forums. Now Consumer Dispute Redressal Forums are provided under the Consumer Protection Act 1986. And this is the structure of Consumer Dispute Redressal Forum. We'll start from the district. We'll start with the district forum. Now this is at the base of this whole structure of dispute redressal forums. And in district forums, again, have a look, it will be hearing cases up to rupees 20 lakh. So for example, if a customer has been sold a television, let's say it costs 60,000, let's say it's a high-tech television and it is costing 60,000, and suppose he is not happy and satisfied with the quality of he feels that he has been missold, or suppose he has been sold an insurance which he is not happy about, he is he feels that he has been missold, he has not been provided all information before purchasing that particular product or service, then he can go to district forum. So he can go to district forum if the amount in contention is up to rupees 20 lakhs. Earlier this limit was much lower, then it was revised around 2000. So if the amount in contention is up to rupees 20 lakh, he can go to district forum straight away. In case the amount is contention is beyond 20 lakhs, then he does not need to go to the district forum, he will have to go to the state forum. You understand? In case the amount is more than 1 crore, he will have to go to straight away National Consumer Courts. Now, who are all are the members of the district forum, and what is this district forum meant for? He will lodge his complaint against the seller in the district forum, and how he will be lodging this complaint, we'll have a look at that also. So he'll be lodging his complaint, and there his case would be heard. So these are all basically quasi-judicial bodies. Quasi-judicial means they are not entirely judicial, they are quasi means partially judicial bodies. So here you would not find all the members of the forum, all of them being from the judicial background, and that is why I am calling them quasi-judicial bodies. So there in district forum, if the amount that is contesting or the amount in contention is rupees 20 lakh, he can lodge a case against the service provider or against the seller here, and there his case would be heard and would be decided on merits. It may so happen that he may be awarded compensation. It may so also happen that he may not be able to prove his point and prove his case, and then his appeal for compensation may be rejected by the forum also. So this is the job that the district consumer dispute redressal forum performs. Now, who all are the members of the district forum? The forum would be presided over by a person who is qualified to become a district judge. He may or may not be a district judge, but he should have the qualification to become a district judge. He would be the president of the forum. There would be a lady social worker, and then there would be an educationist or a respected businessman with knowledge of consumer affairs. So these all are the members of the district forum. Now, if somehow he is not, let's say the customer who has gone to the district forum, he is not happy with the ruling. It could be that his argument has been rejected by the district forum. It could be that the district forum has accepted his argument, but the consumer is not satisfied with the amount of compensation. He feels that he should be awarded more compensation. Then what will he do? Then in that case, he may appeal against the ruling of the district forum to the state forum. So he will have to approach the state forum, state consumer dispute redressal forum, and he will appeal against the orders of the district forum. In cases of appeal, these kind of pecuniary limits, they do not apply. Fine. So these kind of pecuniary limits don't apply, which means, let's say, if I have bought a washing machine and I'm not happy with the quality of the washing machine, and I believe that the seller has not provided me complete information, or he has tried to fool me, I'll lodge a case against him in the district forum. Suppose I'm not satisfied with the ruling of the district forum, though the amount that is under contention is less than 20 lakh, it is less, say just 30,000, 40,000, even then I can go in appeal against the order of the district forum, and for that I'll have to approach the state forum. And that is why I have mentioned that the state forums would hear cases up to rupees 1 crore and appeals. So as far as appeals are concerned, there is no pecuniary limit, there is no ceiling as far as appeals are concerned. But in case the product with which the customer is not satisfied, let's say it costs 60 lakh, then he does not need to go, he will straight away approach the state forum. He would not be going to the district forum in this case, because the amount involved is more than 20 lakhs, right? So this is how the district and the state and the national consumer courts actually function. Again, who all are the members? The members are a sitting or a retired judge. Sitting judge means the person who is still judge of the High Court, or a retired judge who has retired as the judge of the High Court. So the president would be either a sitting or a retired judge of High Court, and there would be two eminent persons, people with reputation, good reputation, so they will be part of the state forum. Likewise, we have got the National Consumer Court. In case the amount in contention is more than rupees 1 crore, you can straight away go to National Consumer Court. The other option that you can exercise is when you are not happy with the judgment given by the district forum, or you are not happy with the judgment given by the state forum, then also you can appeal against those judgments. In that case also you can go to the consumer forum. So if you are not happy with the judgment of the state forum, you go to the consumer court. But if you are not happy with the district forum, you can appeal against this ruling in the state forum. Again, if you are not satisfied with the ruling here, then you can go to the National Consumer Court. Who all are the members? We have got 4 members, and then there would be a president. The forum would be presided over by a sitting or a retired SC judge, Supreme Court judge. Now, this amount, whether it is 20 lakhs or 1 crore, now that is determined on basis of value of goods and services paid as well as compensation claim. Now please understand, this is not just the value of goods and services, but also it includes the compensation which has been claimed. I'll give an example. Supposing, for example, you have bought a car, and let's say you're not happy and you want to lodge a complaint against the seller, and let's say the price of the car was 12 lakhs. So naturally you should be going to the district forum. But this is just the value of the good. Suppose you believe that you should be awarded a compensation of, let's say, 10 lakhs. Now this is what you believe. You are claiming a compensation of 10 lakhs. The value of the car was 12 lakhs, but you are claiming a compensation over and above this amount of 12 lakh. You are claiming a compensation of 10 lakhs. The total amount would now be 22 lakhs. In this case, what you'll have to do is, you would have to go to the state forum and not district forum, because the amount is more than 20 lakhs. So this particular limit which has been set is not only the value of goods and services, but also the compensation that you are claiming, right? You understand my point? For example, suppose you bought a washing machine and the washing machine did not come up to your expectation. It did not perform the job as per your expectations. Then what would you do? You will probably be going to district forum. Let's say the cost of the washing machine is just 40,000 and you are going to the district forum. But suppose you want to claim a compensation of 25 lakhs. Then the total amount would be 40,000, that is the value of the good, and 25 lakhs, that is the compensation being claimed by you. So the total amount would be 25 lakh 40,000, and you would have to approach the state forum straight away. This is okay. So you would not be going to the district forum. So this is how you actually approach the various forums, right? And this is what we refer to as pecuniary jurisdiction. So the jurisdiction is decided on the basis of the value of goods and the compensation being claimed by the complainant or the consumer. Consumer would be the complainant, so he would be claiming some compensation plus the value of the goods. So based on that, the jurisdiction would be decided. What do we mean by this? Based on that, it will be decided whether the district forum has a jurisdiction on this particular case, or whether it would be the state forum or the National Consumer Court which will have a jurisdiction on this particular case. So under whose jurisdiction would the particular case fall would be decided based on the value of goods as well as the compensation that has been claimed, right? Now let us talk about a few rules that would be there whenever you are going to a consumer forum, approaching a consumer forum and lodging a complaint. The complaint will have to be filed where the opposite party resides. So for example, supposing the washing machine has been brought from a seller and he carries on his business, let's say in UP. Though you might belong to Uttarakhand, but you will have to lodge a complaint in UP. So you'll have to go to that particular district where the opposite party, in this case the seller, carries on his business or where he resides. So you'll have to go and you'll have to lodge a complaint there. In many books you might have found out this particular clause that in case some case has to be lodged against the publisher, this will only have to be lodged in a particular city where that particular publisher resides. So this is why this clause has been written on the book also. So the complainant will have to go to the place where the opposite party resides or carries on his business, and there in that particular district or in that particular state he will be lodging his complaint. So he will have to approach the consumer forum in that particular district or that particular state. The complaint mode is in person or by post. You can also send in your complaint by post, and there is no requirement of, you don't need to have an advocate. You can file your complaint on your own. There are proper formats which have been given, so you can make use of those formats and you can file your complaint on your own, and there is simply no fee that you need to pay. Full information has to be furnished. So while you are filing your complaint, you will have to furnish all the information regarding the case. You will have to mention your own name and the name of the opposite party, that is the respondent, and you have to mention the addresses. You have to mention the factual details and the proofs. What would be the proofs? The receipts, the other communication that you have had with the seller. So all these would be proofs, and then you will have to submit these proofs also, and then you have to talk about the factual details of the complaint. Again, you also have to ensure that the complaint is filed within a particular time limit. So time limits have been prescribed, and in some cases it is 2 years from the date of purchase. So time limits have also been prescribed, and you have to lodge your complaint within that particular time limit. So the complaint is otherwise going to be time barred. So within 2 years of your purchase you will have to lodge a complaint. Then the time limit for complaint disposal is also prescribed in the Act, and it is 90 days. In 3 months your complaint would be disposed of, which means some or the other ruling would be given in your case. However, because of the various procedural delays, many a time the parties don't turn up when they are asked to come for the hearing, when they are ordered to come for a hearing. Many times it may so happen that the addresses that the summons have are not served on the parties, so they are not able to present themselves on the date of the hearing. Many times some of the parties deliberately, the seller may deliberately want to delay the hearing. So, and many times it may so also happen that there might be a lack of manpower in the forum because of various reasons. The members may be absent because of various reasons. So because of all these things, what happens is that this particular clause that the complaint would be disposed of in 90 days is generally not adhered to. So there are so many violations, and generally the case lingers on for more than 90 days. However, still it is a very effective means to resolve the consumer complaints against the sellers. So procedural delays are witnessed as far as the rulings are concerned. They may take more than 90 days, and the case may not be disposed within the time limit prescribed here, that is 90 days. Again, what all reliefs are ordered by the forums? They may order replacement of the defective good. So in case the good is defective, they may ask the seller, they may order the seller to replace these goods. They may ask the seller to refund the amount. So the goods would be taken back by the seller, and he would refund all the money that he has taken from you as the price of the good. So he will be refunding all the money. He may also be asked to pay you a compensation, right? So there are different types of reliefs which are provided for in this particular act, and the consumer forum may order any of these. Okay, now we have almost completed our discussion on the Consumer Protection Act 1986. Since this is part of the syllabus, we had no option but to study it. But I would want to let you know that the Consumer Protection Act 1986 has now been repealed, and it has now been replaced by Consumer Protection Act 2019, which is an act that basically makes up for the shortcoming in the 1986 Act, and it is more contemporary. What do we mean by contemporary? You'll get to know in a few minutes from now. So the thing that you'll have to keep in your mind is, though yes, you have to prepare Consumer Protection Act 1986 since that has been given in the syllabus, but you always, whenever some questions are asked on Consumer Protection Act 1986, you will certainly mention, after you have written the answer to the question, you will mention at the end that this particular act has now been repealed and it has been replaced by the Consumer Protection Act 2019. We'll have a very brief look at how this Consumer Protection Act 2019, the latest version, is more effective than the 1986 Act. So as I said, it replaces the Consumer Protection Act 1986 and it provides enhanced customer protection. So the customer protection has been enhanced. Now, I told you a little while ago that this is more contemporary. This is more relevant to the current times. Why? Because Consumer Protection Act 1986, at that point of time, there was no concept of e-commerce. There was no concept of online sales and online purchase. We didn't have companies like the Amazon or Flipkart. These aggregators, online platforms, online marketplaces were not there. And that is why that act was not able to deal with cases related to these kind of new businesses, new age businesses, and that is why we came up with a more contemporary act which is known as the Consumer Protection Act 2019, and now it is dealing with not only the e-commerce business, online selling, tele shopping. Now these are the modes which have emerged only in the last few years, and we needed an act which would also cover these modes of business, these modes of business transactions also. So we have now Consumer Protection Act. It is dealing with direct selling also, wherein the manufacturer sells directly to the customer, tele shopping, selling through telephones, telecallers calling you up and trying to sell you some product, multi-level marketing or affiliate marketing. Then we've got e-commerce business. You know already about Amazon, Flipkart, all these e-commerce businesses, and online sales, selling directly online to the customer. So these modes are also now covered under the Consumer Protection Act. This was not being covered by the 1986 Act. Again, introduction of product liability. Now the product liability, which means that who will be liable in case the product is not of the quality that was expected by the customer? Who will be held liable? Would it only be the seller or would it be manufacturer also? Now the manufacturer as well as the seller would be held liable. So both of them can be held liable for the defective quality, for the quality defect in the product and the services. Then complaints can be filed. Now you would recall that earlier the provision in 1986 Act was that the complaint has to be filed where the opponent, the other party, where the seller resides or carries his business, which meant in case, suppose you have purchased something, let's say from Madhya Pradesh, if you want to lodge a complaint, you will have to lodge a complaint in the district forum of Madhya Pradesh or the state forum of Madhya Pradesh only. But now this particular provision has been changed, and that is what we mean by enhanced customer protection. See, complaints can be filed where the complainant resides. So you don't need to go to Madhya Pradesh all the way to Madhya Pradesh to lodge the complaint. You can lodge the complaint in your place of residence also. So in the district in which you reside or in the state in which you reside, you can lodge a complaint. And again, we are also allowing e-complaints, which was not possible earlier. Now pecuniary jurisdiction determined on the basis, you would remember that pecuniary jurisdiction was basically determined on the basis of the value of goods plus, I hope you remember. And if you want me to move back, I'll move back so that you better understand this particular point. Here, the pecuniary jurisdiction was being determined on the basis of value of goods plus the compensation that you are claiming. And there is no basis for claiming a compensation. For a good which is worth just 20 rupees, you can claim a compensation of 20 lakhs also. So let's say you have bought a car, it just cost you 4 lakh, but you are claiming compensation of 25 lakhs. Now though this case fell under the jurisdiction of district forum, but since you are claiming a compensation of 20 lakhs, the total value would be the value of good is just 4 lakh, the value of the car, plus the compensation claimed is 20 lakh, which means the total amount is 24 lakh. Now you need to go to the state forum straight away. You can go to the state forum straight away. So many a times, many of the complainants, many of the consumers they would misuse this particular provision in the 1986 Act to lodge a complaint straight in the state forum or straight away in the national forum. Now this was something that was basically causing so many issues, and that is why now this provision has been brought here. The provision says that the pecuniary jurisdiction would be determined only on the basis of value of goods and services paid. So you are not going to include the compensation that you are claiming for the fault, for the defective quality. So you are not going to claim, you are not going to include that compensation which you are claiming while determining whether you should be going to the district or the state or the national commission. So here, if let's say I've bought a car, again I'm taking the same example, 4 lakh, I might be claiming a compensation of 20 lakhs. But should I go to district forum or the state forum would not be determined based on how much compensation am I claiming. It would be determined on the basis of the value of goods only, which means if the product that I've bought, item that I've bought is worth rupees 4 lakh, I'll have to go to the district forum, though I might be claiming a compensation of 50 lakhs also. Is this okay? So this was again an improvement over the 1986 Act. Again, the pecuniary jurisdiction limits have been now revised. Now district forum can hear cases up till 1 crore. If the amount paid for the goods and services is up to 1 crore, you can go to the district forum, but if it is beyond that, you'll have to go to the state forum up to 10 crores, and if it is beyond that, then you'll have to approach the national commission. Earlier the limits were different. You would recall that in case of district it was just 20 lakhs, in case of state forum it was up to 1 crore, and in case of national commission it was more than 1 crore. So these limits have also been revised upwards. Fine. Again, then there is one more provision which has been brought in, that disputes can also be referred for mediation. Now this is an alternate dispute resolution mechanism, alternate mechanism for resolving the dispute, ADR, alternate dispute resolution mechanism. Some other option to resolve the dispute. And disputes can be referred for mediation. Mediation means somebody would mediate the dispute between the complainant and the seller, and they can be referred for mediation on written consent. But then if the disputes have to be referred to mediation, then there should be consent of both the parties. And why is this being done? So that the resolution can be speedier, because you know that already in consumer forums the limit which has been prescribed for the disposal of complaints is 90 days, and at times it goes beyond that because of various procedural delays. Now if you want a speedier resolution, naturally both the parties would want a speedier resolution, and for that to happen, what happens is the forum will be referring the dispute for mediation by a mediator, but this will only be done by the forum when both the parties agree on this particular point. If either of the parties is not ready, they are not consenting, then it would not be possible for the forum to refer the dispute for mediation. This is fine, and the whole objective behind doing this is to speed up the resolution of the dispute. This is fine. So this is how changes have been brought about in Consumer Protection Act 2019. I hope you have understood this. The last thing which we need to discuss is the provision for Central Consumer Protection Authority. Now there is a provision for Central Consumer Protection Authority also in Consumer Protection Act 2019, and this was one more provision which was not there in the 1986 Act. Now let's have a very brief look at the Central Consumer Protection Authority. It protects and enforces the interest of the consumers. Again, you understand this point. It has the power to investigate and take action against violation of the Consumer Protection Act 2019. So it can investigate and take action against the violation of the various provisions in the 2019 Act. It can take action and impose monetary penalty against misleading advertisements, and it can take suo motu. You don't need to lodge a complaint. If a particular firm has come up with a misleading advertisement, for example, then they can take suo motu actions. They can take actions on their own. They can take cognizance on their own. There is no need for a complaint to be lodged in front of the authority. They can take cognizance on their own. They can also take action against celebrities who endorse such advertisements which are misleading advertisements. For example, some of the fairness creams claim that the skin tone can be change within a day or within 48 hours. So in cases of such kind of misleading advertisements, even if there's a celebrity who's endorsing these kind of products, then even the celebrity can be acted against. Even actions can be taken against these kind of celebrities. As I said, they can initiate suo motu. Suo motu means on their own. No need to lodge a complaint in front of the Central Consumer Protection Authority. They can take action on their own. They can pass direction for product recall. So in case they find out, for example, they find out that a particular brand of mobile phone heats up and it may catch fire, so they can direct the manufacturer, direct the seller to recall, to take these brand of mobile phones back, and not to sell it to customers. So they can order these kind of things. They can pass directions in this regard. So they can pass directions for recalling such defective product or discontinuing some defective service. They can order refunds, and they can file class action suits on behalf of multiple consumers. What do we mean by class action suits? See, class action suits have, what are they? Please understand. Let's say that I have been duped by a particular firm, and there are so many other customers like me who have also been duped by that particular firm. So we don't want to file cases individually, because that is certainly going to be a time consuming thing, and it will also require my time, and a little bit of my money would also be spent on that. So rather than that, it may so happen that all the customers may come together and they file the case as one single entity. Now this is an example of a class action suit, and on behalf of the customers, the authority can file such class action suits. So class action suits which are basically filed on the behalf of more than one customer, which are basically filed on the behalf of a group of customers. All of these customers have a grouse against, are dissatisfied with some product quality or service quality, and so they complaint, the suit or the case is lodged against the seller on behalf of all the consumers. So this is one more thing which is there that the Consumer Protection Authority does. And please understand and remember that they can go for suo motu process. There is no need for somebody to lodge a complaint, then only they will initiate action. No, they can initiate action on their own. So maybe it may so happen that they come across a news item, they come across some report on the defects in a particular product, and they can initiate suo motu action. They can order that particular product to be recalled, or if it is a service, they can order for the service to be discontinued. They can order refund by the seller to the consumers, and they can also file class action suits on behalf of the multiple consumers. So this is another innovation that the Consumer Protection Act 2019 has brought in. Thank you very much. With this, we are ending this session on the Consumer Protection Act 1986 Unit 2. Now we are through with Unit 2, and very soon we'll be having a test, so kindly remain